The FBI knew he was killing people. This is not alleged. This is not the product of investigative journalism piecing together fragments of a story the government would prefer remained hidden. This is in federal court records, entered into the permanent record of the United States federal court system by juries that heard the evidence and judges who reviewed it and wrote opinions using words like outrageous to describe what the Federal Bureau of Investigation did. This is in a Department of Justice Inspector General report, produced by the government's own internal investigators, that documents in bureaucratic language precisely calibrated to understate rather than overstate its conclusions how FBI field offices across the country allowed their informants to commit violent crimes, including murder, and actively concealed that conduct from the public, from local law enforcement, and from the families of the dead. The FBI had a man on its payroll. He was a mob boss in South Boston, Massachusetts. He ran a criminal empire, extortion, drug trafficking, loan sharking, murder, and simultaneously provided the FBI with intelligence on the Italian-American organized crime families his organization competed against. His FBI handler grew up with him on the same streets. His handler called him when his associates began cooperating with investigators. His handler told him their names. He killed them. This went on for more than a decade. When local law enforcement in Boston tried to investigate the man, FBI agents interfered with those investigations. When witnesses came forward to testify against him, the FBI's own files on them were passed to the man who had them murdered. When federal prosecutors in other cities began building cases that would have implicated him, FBI agents in Boston ensured those cases went nowhere. The FBI classified his informant status, buried the documents that demonstrated the relationship, and maintained for years the official position that they had no special knowledge of his activities. When I first read Judge Nancy Gertner's 2007 civil judgment, the federal opinion that requires the United States government to pay $101 million to the families of Whitey Bulger's victims, and came to the paragraph where she summarizes what the FBI's conduct produced, the sentence I wrote in the margin of my notes was, they paid, not metaphorically, with money, from the Treasury Department, written checks. To the families of people the FBI's own conduct helped murder. The government paid, admitted liability in federal court, and the supervisors who designed, authorized, and oversaw the program that produced these deaths, not one of them went to prison for it. This is a story about an institution that decided, at the highest levels where such decisions are made, that the value of a productive informant exceeded the value of the lives that informant ended, and then spent decades making sure you would never find out, and then, when you found out, made sure that the institutional logic that produced the decision was protected from accountability. The specific form of institutional failure this video documents is not dramatic in the way that dramatic crimes are dramatic. There is no single moment of decision, no smoking gun memo in which a named official authorizes the FBI to protect a murderer. There are instead hundreds of individual decisions by handlers, supervisors, special agents in charge, and headquarters officials, each of which is defensible on its own terms within the institutional logic of the informant program, and each of which contributes to a cumulative outcome that is not defensible by any standard a reasonable person would apply to it. The FBI knew that is not the conclusion of a conspiracy theory. It is the conclusion of a federal civil judgment that requires the United States Treasury to write 9-figure checks. It is the conclusion of a criminal prosecution that puts an FBI agent in prison for 40 years. It is the conclusion of a Department of Justice Inspector General report that documents the systemic nature of the failure across multiple field offices and multiple years. The FBI knew. The documentation of what it knew and what it chose to do with that knowledge is in the public record. It has been there for more than 2 decades. Before we get into it, hit subscribe and drop a like. The algorithm actively buries this kind of content. The story begins not with a man but with a program, because what happened in Boston and in New York and in cities across America was not the work of a rogue agent. It was the work of a machine, and the machine had a name and a budget and the full institutional authority of the Federal Bureau of Investigation behind it. Event 1, the Top Echelon Program, How the FBI Built the Machine, 1961-1970s. J. Edgar Hoover runs the FBI for 48 years, from 1924 to 1972, and for most of that time, he insists publicly that organized crime does not exist as a coherent national phenomenon. The American Mafia, the Cosa Nostra, the network of Italian-American criminal families that coordinate across city lines and state lines and family lines to control gambling, labor unions, narcotics, and political patronage across the United States. Hoover denies it. He denies it in congressional testimony. He denies it in press releases. He denies it in interagency meetings where Treasury Department agents and Federal Narcotics Bureau investigators lay evidence of the national structure directly in front of him. The denial is so consistent, so sustained, and so implausible given the available evidence that the historical consensus, developed across decades of declassification and investigation, is that Hoover's denial is not ignorance. It is institutional policy. The FBI does not investigate organized crime because Hoover does not want to investigate organized crime, and Hoover does not want to investigate organized crime because investigating organized crime would reveal how extensively organized crime has penetrated the political institutions that protect Hoover's empire. That assessment is the subject of a different video. What matters here is what changes it. The change is forced on Hoover in October 1957. State police in upstate New York, acting on a routine tip about suspicious traffic at a rural property, discover 63 men meeting at the estate of Joseph Barbara in Appalachian, New York. The men are from across the country. They are, by their subsequent identification, senior figures in Italian-American organized crime from New York, Chicago, Tampa, Los Angeles, Detroit, and a dozen other cities. They scatter into the woods when police appear. 28 of them are detained. The meeting is so transparently an organized crime national summit that no public position Hoover could take would be credible. He cannot deny it. The gathering he has spent 30 years insisting does not exist just got caught having a picnic in upstate New York. The top echelon criminal informant program is established in 1961 as the FBI's systematic response to the embarrassment of Appalachian. Its purpose is to develop a network of high-level informants inside organized crime, not street-level operatives providing tactical intelligence but senior figures who can provide strategic intelligence about the internal workings, hierarchies, decision-making, and planned operations of the organized crime families the Bureau is now publicly committed to dismantling. The logic is coherent. You cannot understand a secret organization from the outside. You need people on the inside who will talk. The structural problem is also coherent. To recruit a high-level informant inside organized crime, you must offer that informant something. What you offer is protection, protection from prosecution, protection from investigative attention, protection from the consequences of the crimes the informant is already committing and will continue to commit while providing intelligence to the FBI. A senior figure in a criminal organization who stops committing crimes stops being senior. He also stops being useful as an informant. The FBI's top echelon asset is, by definition, an active criminal who continues his criminal activities while the Bureau provides cover. The internal authorization framework the Bureau develops to govern this is breathtaking in its deliberate imprecision. The program authorizes informants to commit otherwise illegal activity. That phrase is in the program's written guidelines. It is not defined. It is not bounded by categories of crime. It does not specify which crimes are authorized and which cross a line no FBI director wants to put on paper. The specific question of whether otherwise illegal activity includes murder is never explicitly answered in the written guidelines, not because the people who wrote them failed to consider the question, but because answering it explicitly would require the FBI to have a document stating that the Bureau authorizes murder, which would be a document no institution wants to exist. The FBI handler, the specific agent assigned to manage a specific informant, is the person who determines in practice what otherwise illegal activity covers for his asset. Handler career advancement depends substantially on informant productivity. A handler whose informant generates arrests, indictments, and convictions of senior organized crime figures is a career success. A handler whose informant produces nothing is a liability. The institutional incentive structure rewards keeping informants operational and valuable. You keep an informant operational and valuable by protecting him from the consequences of what he does. You protect him by not reporting what he does too accurately, and by using the classification of informant files to insulate that non-reporting from external scrutiny. The special agent in charge of each FBI field office receives institutional credit when informants in his office produce significant results. He has every reason to support handlers who maintain productive relationships and no institutional reason to examine those relationships too carefully. The supervisory structure that should provide oversight of the handler-informant relationship is staffed by people whose careers run on the same incentive track as the handlers they supervise. This is the machine. It is designed to produce the specific failure that Boston and New York and other cities document in their own particular registers. The machine does not malfunction in any of these cases. It functions exactly as the incentive structure it was built on was always going to produce. There is one additional structural feature of the top echelon program that the subsequent investigations document, and that deserves emphasis as context for what follows: the deliberate isolation of the handler-informant relationship from external oversight. FBI informant files are classified at a level of compartmentalization that makes them inaccessible not only to the public, but to other law enforcement agencies, state police, local police departments, DEA, the prosecutors in federal district offices who build criminal cases from FBI intelligence. An FBI handler knows things about his informant's criminal activities that the people who are trying to prosecute that informant do not know. A handler who chooses to suppress information from the informant file, to omit in his reporting the criminal conduct the informant is engaged in, can maintain that suppression indefinitely against any external inquiry, because no external agency can access the file. This compartmentalization is, in its original design, a legitimate security measure. Intelligence source protection is real. Informant identities disclosed to wide audiences become informant corpses. The problem is that the same compartmentalization that protects legitimate intelligence sources also protects the corruption of handlers who use the compartmented system to maintain a personal relationship that serves their informant rather than their institution. The FBI's internal oversight is supposed to compensate for the external inaccessibility of informant files. Supervisors are supposed to review handlers' reporting. Senior officials are supposed to conduct periodic assessments of significant informant relationships. The program's guidelines are supposed to establish the standard against which handler conduct is measured. In practice, as the Bulger case and the 2005 IG report both establish, the internal oversight is conducted by people with the same institutional incentives as the handlers they supervise. They are reviewing the records that handlers produce, and handlers who are protecting their informants produce records designed to make the relationship look productive and the informant's criminal conduct look manageable. The oversight reviews the record. The record is the problem. The names change. The neighborhoods change. The specific criminal organizations change. The outcome does not change because the institutional logic does not change. Understanding this is the prerequisite for understanding everything that follows. John Connolly is not an aberration. He is a product. Whitey Bulger is not a failure of the system. He is the system working as designed. Event 2. Whitey Bulger, South Boston before the deal, 1950s, 1970s. South Boston in the decades after World War II is a neighborhood that operates, in certain respects, as its own sovereign territory within the city. It sits on a narrow peninsula south of downtown Boston, bounded by water on three sides and by a mutual suspicion of the world outside its borders that is almost architectural in its permanence. The triple-deckers on the residential streets are owned by families who have lived in the same blocks for 2 and 3 generations. The political infrastructure of the neighborhood runs through the Catholic parishes, the social clubs, the barrooms, and the ward organizations that translate loyalty into patronage and patronage back into loyalty in a cycle that has sustained itself since the Irish immigration of the 19th century. The neighborhood produces politicians, and it produces criminals, and it regards both with a loyalty that does not always distinguish clearly between the two. James Joseph Bulger is born September 3, 1929, in the Old Harbor Housing Project, a public housing development in South Boston the third of 6 children of a laborer who loses his arm in a factory accident and a woman who holds the family together by force of character. He is called Whitey from childhood for the pale blonde hair that darkens as he ages. His first arrest comes at 14 for theft. His criminal record through the 1950s includes armed robbery, bank robbery, and assault. It produces a federal sentence in the mid-1950s that eventually lands him at Alcatraz Federal Penitentiary from 1959 to 1962, where in a detail that belongs in a different video, but that establishes early the quality of his relationship with federal institutions. He volunteers to participate in CIA-sponsored LSD experiments conducted on inmates under the MK Ultra program, apparently believing the participation might reduce his sentence. It does not, and his retrospective accounts of the experiments are not favorable. He is already learning that what the government offers and what the government provides are different things. By the early 1970s, Bulger is a senior figure in the Winter Hill Gang, the predominantly Irish-American criminal organization based in Somerville, Massachusetts, that operates across the Boston metropolitan area in competition with the Patriarca crime family, the New England branch of the Italian-American organized crime structure with its base of power in Providence, Rhode Island. The Winter Hill Gang's criminal economy is extortion, loan sharking, gambling, and as the decade progresses, narcotics. It is not, in the early 1970s, the dominant criminal organization in Greater Boston. It aspires to be. Howard "Howie" Winter runs the Winter Hill Gang through the early and mid-1970s. Bulger is his lieutenant, valued, trusted, and feared within the organization's hierarchy in the specific way that men who are both strategically intelligent and personally willing to commit violence are valued and feared inside criminal organizations. The violence is not incidental to Bulger's position. It is foundational to it. Former Winter Hill associates testifying in subsequent federal proceedings consistently describe Bulger as a man who participated personally in violence rather than delegating it, who was not troubled by what he did in the way that even some career criminals are troubled, who approached the murder of people who presented problems to his organization as a matter to be attended to efficiently and without sentiment. His brother Billy Bulger's trajectory runs parallel and perpendicular. Billy Bulger is elected to the Massachusetts State House in 1960 and to the State Senate in 1970. He will become president of the Massachusetts State Senate, the most powerful legislative position in the Commonwealth, a title he holds from 1978 to 1996. He is by all accounts a formidable political figure, intelligent, loyal to South Boston in the way that South Boston politicians are loyal to their neighborhood, and publicly committed to the institutional values of the Democratic Party of Massachusetts. The relationship between Billy and Whitey Bulger is a subject that Billy Bulger will spend most of his adult public life declining to discuss in detail. It is documented that Billy Bulger is aware of his brother's criminal activities. What he does or does not do about that awareness is a question the public record does not fully resolve. By 1979, Howie Winter is in prison on charges of fixing horse races. Bulger has maneuvered himself through a combination of organizational patience, strategic elimination of rivals, and the specific competitive advantage that he is in the process of acquiring through his relationship with the FBI into the position of the Winter Hill Gang's effective leader. He controls the criminal economy of South Boston with a thoroughness that subsequent federal investigation characterizes as essentially monopolistic. Extortion payments from businesses in the neighborhood are collected with the regularity of a tax. People who do not pay are visited. People who present problems disappear. The specific competitive advantage Bulger acquires through his FBI relationship is the one that makes his control of South Boston's criminal ecosystem sustainable against the normal pressures that bring criminal organizations down. He knows in advance who is talking to law enforcement about him. He knows this because the FBI tells him. And the FBI tells him because he provides the FBI with intelligence that the FBI values more than it values the lives of the people Bulger kills when he gets the names. That exchange, Bulger's intelligence for the FBI's protection, is organized and managed by a man Bulger has known since childhood, a man who grew up in the same housing project, a man whose career and life are about to become inseparable from Bulger's in ways that neither of them can undo. The specific detail that the subsequent federal investigation establishes about Bulger's criminal operation in the 1980s, the decade in which his FBI protection is at its most operational and most lethal, is that the protection is not passive. Connolly does not simply allow Bulger to operate by declining to investigate him. He actively degrades the investigative capacity of other agencies trying to investigate him. He interferes with state police wiretap operations. He disrupts DEA drug investigations. He warns Bulger about surveillance operations before they produce evidence. He turns the FBI's institutional infrastructure, its file systems, its interagency communications, its relationships with local law enforcement, into a tool for protecting a murderer from the investigative scrutiny that would end his operation. The cost of this active protection extends beyond the specific people Bulger kills. It extends to every criminal case that stalls because a surveillance operation is burned, every potential cooperator who decides not to come forward after watching what happens to people who do, every business in South Boston that pays its extortion to the Winter Hill Gang because the FBI is maintaining the credibility of the man collecting it. The direct costs, the murders, are the visible part of the accounting. The indirect costs, the criminal economy that Bulger's FBI protection sustains for 15 years, are diffuse, unquantifiable, and distributed across the neighborhood and the city in ways that no civil judgment will ever fully capture. What the judgment captures is 11 names. It cannot capture everything else. The Bulger case does produce one form of systemic change that deserves to be noted accurately: the 2002 revision of the Attorney General's Guidelines on Confidential Informants. The revised guidelines impose authorization requirements, documentation standards, and supervisory oversight procedures that are, on paper, substantially more rigorous than what existed during the Bulger years. Handlers are required to obtain formal pre-approval before authorizing informant criminal activity above a specified threshold. Long-term informant relationships require periodic review by officials not involved in the day-to-day operation. The reporting requirements for informant criminal conduct are strengthened. These are real improvements in the formal structure of the program. The 2005 Inspector General Review finds, 3 years after the guidelines' implementation, that compliance is partial. Some handlers are meeting the new requirements, some are not. The supervisors reviewing handler compliance are, in many cases, the same supervisors who have the same career incentives as the handlers they supervise. The revised guidelines are a better set of rules operating within the same institutional culture and the same incentive structure. Whether they are sufficient to prevent the next Bulger is a question that the classification of current informant files makes impossible to assess from outside. The more fundamental question, whether a law enforcement program that authorizes senior criminals to continue committing crimes in exchange for intelligence is compatible with the constitutional rights of the people those criminals victimize, is not addressed by the guidelines revision. It is not addressed by the DOJ IG report. It is not addressed by any institution with the authority to address it. The program continues. The authorization continues. The classification continues. The families of the next 11 names have not yet started counting. Event 3, John Connolly, the handler who crossed every line, 1975-1990. John Joseph Connolly Jr. grows up in the Old Harbor housing project in South Boston in the 1950s, the same project, the same streets, the same social geography as the Bulger family. He is 9 years younger than Whitey, which means he grows up in Whitey's shadow in the specific way that boys in neighborhoods with clear social hierarchies grow up in the shadow of older figures who are powerful, feared, and generous in the calculated way that powerful men are generous with the children around them as a form of social investment. The specific formative story Connolly tells in interviews, in letters, in his public statements across decades of trials and imprisonment is that when he was a boy, Whitey Bulger gave him a fish he'd caught. It is a story he returns to consistently enough that it has the quality of a founding myth, the gift that created an obligation that organized a life. Whether the story is true as told, embellished, or a symbolic compression of something more diffuse, It is the narrative Connolly constructs his self-understanding around. He is, in his own account of himself, a South Boston boy who grew up to be an FBI agent and never entirely stopped being the kid from the same project as Whitey Bulger. Connolly joins the FBI in 1968, completes training, and works field assignments in New York and San Francisco before engineering a transfer to the Boston field office in 1973. By 1975, he has recruited James Bulger as a top echelon criminal informant and has filed the internal paperwork that gives the relationship an institutional legitimacy it will maintain with increasing fragility for the next 15 years. The formal justification for the Bulger recruitment is coherent in its institutional logic. Bulger's Winter Hill gang is in direct competition with the Patriarcha crime family for control of New England's criminal economy. The FBI wants the Patriarcha family dismantled. Bulger wants the Patriarcha family out of his territory. Recruiting Bulger as an informant gives the FBI intelligence access to the Patriarcha family's operations through the eyes of its primary competitor. The intelligence Bulger provides is, on its own terms, genuine and valuable. It contributes to prosecutions of Patriarcha family members that are real law enforcement achievements. This is the part of the story the FBI will point to for decades as evidence that the relationship produced legitimate results. What the institutional assessment does not count is the other side of the ledger. Connolly's supervisor is John Morris, the head of the organized crime unit in the Boston field office. Morris is not a passive recipient of Connolly's reports, he is a participant. Federal prosecutors establish, through Morris's own subsequent cooperation with investigators, that Morris accepts approximately $7,000 in cash from Bulger and Flemmi across the duration of the relationship. Delivered in installments at meetings, money paid, in the functional moral economy of the arrangement, to ensure that the supervisor responsible for overseeing the informant relationship does not look too carefully at what the relationship actually involves. Morris also participates operationally. He is present at meetings with Bulger and Flemmi, at which law enforcement intelligence is shared. He approves informant reports he knows are incomplete. He signs off on assessments of the relationship's value that reflect Connolly's management of the record rather than the operational reality. When Morris eventually cooperates with federal investigators and testifies against Connolly, he provides the most complete insider account of how the corruption operates at the supervisory level. As the price of that testimony, he receives full immunity from prosecution. He is never charged with any crime. He retires. He lives in the American Southwest. The government decides that his testimony against one corrupt agent is worth more than accountability for his own participation in the corruption. What Connolly delivers to Bulger across 15 years of operation is intelligence. FBI files on potential witnesses, identities of people who have approached investigators, status of investigations, locations of surveillance, timing of planned law enforcement actions. The specific product is best understood through its consequences. When someone approaches the FBI to cooperate against Bulger, Connolly learns of it through his access to field office intelligence. He tells Bulger, "The person who approached the FBI dies." The financial accounting of the Connolly-Bulger relationship, established through federal prosecution, is that Connolly receives approximately $235,000 from Bulger and Flemmi across the years of the relationship, paid in cash. He uses some of this money to purchase a condominium. He uses some of it for daily expenses. He uses it in ways that leave financial records that become prosecution exhibits. His career during this period is, by the FBI's own institutional assessment, successful. He receives commendations. He is regarded within the Boston field office as one of its most productive organized crime agents. This assessment is accurate by the narrow metric the FBI is applying: prosecutions of Patriarcha family members. It is catastrophically wrong by the metric the FBI is not applying: what its protection of Bulger costs the people who enter Bulger's orbit and cannot escape it. Event 4. The murder list: 11 people who died for the FBI's asset, 1970s, 1980s. The federal court record in United States v. Bulger identifies 19 murders that Bulger and his associates commit across approximately 2 decades. The jury at his 2013 trial convicts him on 11 of the 19 charged murders. The the murders that occur while Bulger is actively on the FBI's payroll as a registered top echelon informant number at least 11. The FBI's protection is not incidental to these murders. It is the operational context that makes them possible, that makes Bulger confident he will not face the investigative pressure that would otherwise constrain a criminal of his visibility and reputation. Brian Halloran is 32 years old in the spring of 1982. He is a peripheral associate of the Winter Hill Gang, not a senior member, not in Bulger's inner circle, a man who does occasional work for the organization without being part of its core. He is also a man who has become a liability because he has information about the murder of Roger Wheeler, a Tulsa businessman, and he has decided to do something with it. He approaches the FBI. He says he wants to cooperate. He provides information about the Wheeler murder. He says he is willing to testify against Bulger and Flemmi. The FBI agent who receives his initial approach is not John Connolly, but Halloran's approach is documented in FBI records. Those records flow through a field office where Connolly has access to organized crime intelligence files. The federal prosecution of Connolly establishes that Connolly informs Bulger that Halloran is cooperating with the FBI. The precise mechanism, phone call, intermediary meeting, is not established with certainty in the trial record. The sequence is Halloran approaches the FBI. Bulger learns Halloran dies. On May 11, 1982, Halloran is sitting in a car on Northern Avenue near the Boston waterfront. Bulger, not an intermediary, Bulger himself, according to the subsequent federal proceedings and the testimony of Kevin Weeks, who is present, pulls alongside the car in a vehicle and opens fire. Halloran is hit multiple times, so is the man in the car with him. Michael Donahue is 32 years old on May 11, 1982. He is from Dorchester. He is a truck driver. He has a wife named Patricia and 3 sons. He has no criminal record. He has no connection to organized crime. He is giving Brian Halloran a ride because that is the kind of man he is. He is in the wrong car at the wrong moment in a city where the FBI is maintaining a murderer's operational security, and he is shot and killed in a parking lot alongside a man he is doing a favor for. His wife Patricia will spend the next 25 years pursuing accountability through the federal civil courts. She will testify at proceedings related to the civil case. She will describe raising 3 sons alone. She will receive, eventually, a check from the United States Treasury Department. This is what the government of the United States offers in compensation for the conduct of its agents: a check from the Treasury, signed, delivered, enough to close the case file. Roger Wheeler is 61 years old on May 27, 1981. He is the founder and chairman of Telex Corporation, an Oklahoma technology company, and he has purchased World Jai-Alai, a legal gambling operation running facilities in Hartford and Miami. Examining his new acquisition, he discovers that the profits are being systematically skimmed by organized crime. He does not know it is the Winter Hill Gang. He knows the numbers are wrong. He begins asking questions. The questions will lead, inevitably, to people who cannot afford the answers to be found. John Martorano, a Winter Hill hitman who will eventually admit to 20 murders across his career, shoots Wheeler once in the head while he sits in his car in the parking lot of Southern Hills Country Club in Tulsa, Oklahoma. Wheeler is killed because asking questions about irregularities in a business he legally purchased is, in the economy of Whitey Bulger's Boston, a capital offense. John Callahan is 45 years old in July 1982. He is a former president of World Jai-Alai, the man who arranged the connection between the gambling operation and the Winter Hill Gang. With the FBI looking at the Wheeler murder, Bulger and Flemmi assess that Callahan is the next person whose cooperation would be catastrophic. Martorano kills him in a parking garage at the Fort Lauderdale Hollywood International Airport in Florida. He is found in the trunk of a rented car. The Florida prosecution of Connolly, 26 years later, will be predicated on the theory that Connolly's intelligence enabled this murder on Florida soil, making it a Florida state crime. Deborah Davis is 26 years old when she is murdered in 1981. She is the girlfriend of Stephen Flemmi. She is killed, in the account established through subsequent federal proceedings, because Flemmi fears she has learned too much about his criminal activities and his FBI informant relationship to be safely allowed to live. Her body is buried. Deborah Hussey is 26 years old when she is murdered approximately 4 years later. She is the stepdaughter of Flemmi, the daughter of his long-term girlfriend. Federal prosecutors characterize her relationship with Flemmi as one he imposed on her beginning in her childhood. She is murdered in the court record because she threatens to expose that relationship. Both women are buried in the same location in South Boston. Their bodies are recovered by federal investigators in the year 2000, nearly 2 decades after their deaths. These are 6 of the 11. Each has a name. Each has a family. Each is a person who is dead, in whole or in part, because the Federal Bureau of Investigation decided that the intelligence value of Whitey Bulger exceeded the value of the lives he was ending with information the FBI provided. The decision is never made explicit in any document. It does not need to be. The institutional incentive structure makes it automatically, through 1,000 individual choices by individual agents and supervisors who understand, without needing to be told, what the program requires of them. Event 5, Gregory SCARPA SR. The Grim Reaper on the Payroll, 1960s-1990s. Boston is not unique. This is the essential fact that the 2005 DOJ Inspector General report establishes, and that the specific case of Gregory Scarpa SR illustrates with a precision that makes it impossible to dismiss the Bulger case as a local anomaly produced by a particularly corrupt set of agents in a particularly insular city. Gregory Scarpa SR is born in Brooklyn in 1928. He is, by the time of his adult criminal career, a made member and senior operative of the Colombo crime family, one of New York City's 5 Italian-American organized crime families, with a specialty in enforcement that earns him the nickname, the Grim Reaper, from associates who use this designation with a respect that contains no detectable irony. He commits his first documented murder in the 1950s. The count that federal prosecutors eventually attribute to him, reconstructed from cooperating witness testimony and investigative records across his career, is approximately 50. 50 murders across 4 decades by a man who is simultaneously, for most of that career, registered as a top echelon informant with the Federal Bureau of Investigation. Scarpa is recruited as an FBI informant in the early 1960s. The specific moment of his recruitment, disputed in its details but documented in its outline, involves an episode in 1964 that captures, better than any single example in this research, the institutional logic of the top echelon program. During the FBI's investigation of the murders of civil rights workers James Chaney, Andrew Goodman, and Michael Schwerner in Mississippi, investigators need information about the location of the bodies and the identities of those responsible. Local Klan members are not forthcoming through normal investigative means. The solution that emerges, apparently sanctioned at levels above the field, involves sending Gregory Scarpa from New York to Mississippi to obtain the information using methods the FBI's own agents cannot officially employ. Scarpa, according to subsequent accounts documented by investigative journalist Angela Clement and confirmed in part through court proceedings, abducts a Klan member, holds a gun to his head, and persuades him to provide the information. The FBI recovers the bodies of Chaney, Goodman, and Schwerner from the Mississippi Dam site where they have been buried. This operation is not in any official FBI record. It exists in the informal record of Scarpa's relationship with the Bureau, in the understanding, established between Scarpa and his handlers from the beginning of his informant career, that the Bureau will provide cover for what Scarpa does in exchange for what Scarpa provides. The Mississippi operation is the originating transaction. The cover it requires, the debt it creates, establishes the framework for everything that follows. Scarpa's primary handler from 1980 to 1992 is Supervisory Special Agent R. Lindley DeVecchio, assigned to the FBI's New York field office. DeVecchio is a respected organized crime agent, regarded within the Bureau as a skilled handler of difficult assets. His relationship with Scarpa is, in the documentary record assembled through court proceedings and investigative reporting, a replication in a different city, with different names, inside the Colombo rather than Winter Hill criminal structure of the Connolly-Bulger dynamic. DeVecchio provides Scarpa with information. The information helps Scarpa survive and succeed in his criminal career. Scarpa provides DeVecchio with intelligence. The intelligence helps DeVecchio succeed in his professional career. The Colombo War, a bloody internal conflict within the Colombo family that runs from 1991 to 1993, is the most damaging specific episode of the DeVecchio-Scarpa relationship. The war, a power struggle between the imprisoned family boss Carmine Persico and a faction led by Victor Orna, produces 12 deaths and dozens of wounded across 2 years of street violence in Brooklyn and Staten Island. Scarpa is a committed Persico loyalist who participates in the war directly, conducting at least 3 murders of Orna faction members during the conflict. Former FBI agent Chris Favo, who works in DeVecchio's unit during this period, subsequently reports to FBI internal investigators that DeVecchio provided Scarpa with intelligence about the locations and movements of Orna faction members, intelligence that Scarpa uses to identify and kill his enemies. Favo's account, if accurate, means that a supervisory FBI agent is providing targeting intelligence to an active participant in a gang war. It means that the FBI is, operationally, a participant in the Colombo War, not on the side of law enforcement, not on either side as such, but on the side of the specific asset whose continued operation DeVecchio's career depends on. Favo reports his concerns to FBI supervisors in 1994. The Bureau conducts an internal investigation. The investigation concludes there is insufficient evidence to support disciplinary action against DeVecchio. He retires in 1996. He receives his full pension. He has not been charged with any crime by the federal government. Brooklyn District Attorney Charles Hines indicts DeVecchio in 2006 on 4 counts of murder in connection with his provision of intelligence to Scarpa during the Colombo War. The indictment is dismissed in 2007 when prosecutors determined that their primary witness, Lynn Schiro, a woman who was Scarpa's long-term companion and who claims first-hand knowledge of DeVecchio's intelligence sharing, has provided inconsistent accounts that undermine the prosecution's case. DeVecchio walks. He publishes a memoir, he makes public appearances, he attends true crime events, he lives in retirement in Florida, a free man with a pension and a book deal. The Scarpa case illuminates the Boston case from a different angle and adds a dimension that the Connolly prosecution, focused tightly on Connolly's individual conduct, does not fully surface. In Boston, the corruption runs from handler to supervisor. Connolly is the operational engine. Morris is the supervisory cover. The institutional hierarchy above Morris, the field office leadership, the headquarters oversight of the Boston organized crime program, is implicated in the cover-up through the accumulated decisions not to look carefully at what the organized crime unit is doing with its most productive informant. In New York, the Scarpa case implicates a similar hierarchy without producing similar accountability. The FBI's internal investigation of DeVecchio in 1994, the investigation triggered by Chris Favo's report that DeVecchio was providing targeting intelligence to Scarpa during the Colombo War, is conducted by the FBI. It concludes, after a review conducted by the institution whose agent is under scrutiny, that there is insufficient evidence to support disciplinary action. This is the institutional self-investigation problem in its purest form. The agency investigates its own agent, using its own investigators, reviewing its own records, applying its own standards of what constitutes sufficient evidence, and reaches the conclusion that is most convenient for the agency. The agent retires. He collects his pension, he writes a book. The broader principle established by the combination of the Boston and New York cases is one that the 2005 IG report documents across multiple additional cities without the same name recognition. When a productive FBI informant commits crimes, the institutional machinery of the Bureau produces consistent pressure toward protection rather than accountability, and the specific people who bear the cost of that protection, the victims, the families, the witnesses who don't make it out, have no access to the classified files that would document what happened to them and why. Event 6. The tips that became death sentences, 1975-1994. The operational mechanism of what Connolly does is simpler than its consequences suggest. He reads files. He has access as a field agent in the Boston Organized Crime Unit to the organized crime intelligence files maintained in the field office, the records of ongoing investigations, potential witnesses, cooperating individuals, surveillance operations, and the general intelligence picture of Boston's criminal landscape that the Bureau maintains as the working foundation of its law enforcement activities. He reads these files as part of his normal daily work. When those files contain information relevant to Bulger's operational security, the identity of a potential witness, the target of a surveillance operation, the timing of a planned enforcement action, Connolly removes that information from the institutional context where it exists to protect the public and transfers it to the personal context where it serves to protect his informant. The financial dimension of the arrangement is documented in federal court. Connolly receives approximately $235,000 across the 15 years of his operational relationship with Bulger and Flemmi, paid in cash, in installments, at meetings between Connolly and his informants that are sometimes described in his official reports as intelligence-gathering sessions. The official reports do not mention the direction of the financial flow. He uses some of the money to purchase a condominium. He uses some of it in ways that leave records recoverable by federal investigators. He is paid for what he provides. He provides death sentences. The Halloran case is the most clearly documented instance of the Connolly mechanism because the sequence of events, approach, disclosure, murder, is compressed into weeks and traceable through the FBI's own records. Brian Halloran approaches the FBI in early 1982. His approach is documented in the field office's intelligence files. Connolly has access to those files. The federal prosecution establishes that Connolly communicates Halloran's cooperation to Bulger. Halloran is murdered in May 1982. The sequence is documented. The causal chain is established in federal court. The jury convicts. What the jury's verdict cannot do is restore Michael Donahue's 3 sons to the father they lose on Northern Avenue on May 11, 1982. Patricia Donahue files her civil claim against the United States government in the early 2000s, when the documentary basis for the government's liability is established through the Connolly criminal prosecution. She describes in testimony and in public statements across the years of litigation what it means to raise 3 children while simultaneously pursuing accountability through a legal system that processes her husband's murder at the pace of institutional justice. The case takes years. The judgment takes years. The check arrives decades after the shooting. The mechanism operates in the other direction as well, and this dimension of Connolly's conduct is perhaps more comprehensively damaging to the institutional integrity of law enforcement in Boston than the murder facilitation alone. Connolly does not only pass intelligence about cooperators to Bulger. He passes intelligence about law enforcement operations to Bulger, which phones are being tapped, which locations are under surveillance, which of his associates are being investigated by which agencies. The Massachusetts State Police, which runs multiple investigations of Bulger and the Winter Hill Gang across the 1970s and 1980s, experiences repeated operational failures that the subsequent federal investigation attributes to Connolly's interference. The DEA investigation of Bulger's drug trafficking operation in the mid-1980s is documented particularly well. The DEA develops a substantial narcotics case against Winter Hill over several years, building informant relationships and surveillance infrastructure that produce genuine evidence of Bulger's involvement in drug distribution across the city. The case approaches a point where charges appear imminent. It stalls. Key witnesses become unavailable. Surveillance operations produce diminishing returns in ways consistent with the targets having been warned. The subsequent federal investigation identifies FBI interference, Connolly providing intelligence about DEA operations to Bulger as a significant factor in the investigation's failure to reach prosecution. There is an internal FBI document that captures the institutional awareness of what is happening. In 1988, FBI Supervisor James Ring prepares an assessment of the Bulger-informant relationship that identifies specific concerns about whether the Bureau is managing Bulger or Bulger is managing the Bureau. Ring notes that the intelligence Bulger provides is, in certain respects, suspiciously convenient. It tends to harm Bulger's competitors and rivals without exposing anyone in Bulger's own organization. Ring's assessment does not produce a review of the relationship. It produces a memorandum that is filed and not acted on. The cover Connolly provides extends to the 1994 warning that Bulger is about to be indicted. A federal grand jury is in the process of returning an indictment against Bulger in December 1994. The information that an indictment is imminent reaches Bulger through channels that the subsequent investigation associates with Connolly and possibly other current or former FBI connections. Bulger withdraws money. He collects identification documents. He leaves South Boston on December 23, 1994. He is not found for 16 years. During those 16 years, the FBI maintains a public posture of active pursuit through its 10 most wanted list, while the subsequent investigation raises questions about whether the fugitive search is conducted with the urgency the Bureau's public statements suggest. The Joseph Salvati case, which runs in parallel to the Bulger case and is in certain respects more disturbing, operates through the same mechanism. In 1965, the FBI has informant intelligence from a man named Joseph Barboza, a mob hitman who is himself a Bureau asset, establishing that Salvati, a small-time hood from East Boston, is not present at the murder of Edward Deegan in Chelsea. The FBI does not disclose this intelligence to Salvati's defense attorneys. Barboza testifies falsely at Salvati's trial. Salvati is convicted and sentenced to death. The death sentence is commuted to life in prison. He serves 30 years before the buried FBI documents are produced in federal court proceedings, and his conviction is overturned in 2001. The FBI's justification for suppressing the exculpatory intelligence is the same justification the program always uses: protecting the source. Barboza's identity as an FBI informant would have been revealed by the disclosure. The informant program is protected. Salvati loses 30 years of his life, and his family loses 30 years with him. His wife, Marie Salvati, spends those 30 years maintaining the position that her husband is innocent, while the federal government, through its representatives and its records, maintains the opposite. She is right and they are wrong and they know it, and the knowing is buried in classified FBI informant files for 30 years. Salvati and his wife are awarded $36 million in civil damages in 2007 in proceedings before Judge Gertner that run concurrently with the Bulger civil cases. The government does not contest the basic facts. It contests the damages calculation. The government of the United States pays $36 million to a man it imprisoned for 30 years for a murder it had evidence he did not commit, and paid that money to protect the classified status of a hitman it was using as an informant. The question of who warns Bulger in 1994 is one the full federal investigation does not resolve with complete certainty. What it establishes is the pattern. Every time Bulger needed to know something that the FBI knew, he found out. The mechanism is Connolly. The result is Bodies, Event 7, the cover UP, How the FBI Buried Its Own Crimes, 1975-1995. The classification of Bulger's FBI informant status is not a single decision made at a single moment by a single supervisor. It is a sustained institutional practice, a continuous series of individual decisions made by multiple people across multiple years and multiple levels of organizational hierarchy that collectively maintain a fiction. The fiction that the FBI's relationship with Whitey Bulger is a standard, appropriately managed, institutionally controlled informant relationship that produces intelligence value without generating inappropriate costs. The internal document management is the primary mechanism. An FBI informant's file, the record of his status, his handler assignment, his reporting, and the authorizations governing his activities is maintained in a classified system separate from the Bureau's general investigative files. Access to the file is restricted to agents with specific designated need to know. When local law enforcement in Boston tries to investigate Bulger, the FBI's organized crime unit can truthfully say that it cannot discuss its files. It cannot discuss its files not because disclosure would endanger an ongoing operation, but because disclosure would reveal that the FBI is protecting the target of those investigations. The Massachusetts State Police runs a wiretap operation on Bulger's South Boston operations in the early 1980s. The operation is technically sophisticated and produces genuine intelligence about the Winter Hill Gang's criminal activities. It also, through channels that the subsequent federal investigation traces to Connolly's intelligence sharing with Bulger, produces results that are systematically degraded by the target's awareness that they are being monitored. Bulger shifts his most sensitive communications. He moves locations. He identifies the surveillance's technical parameters and works around them. The state police investigation is operationally undermined, and the undermining is attributable to intelligence provided by a federal agent to the man the state police is investigating. The Boston Police Department Organized Crime Unit encounters similar frustrations across multiple investigations of the Winter Hill Gang through the 1980s. Investigations that appear to be developing promising intelligence experience unexplained reversals, witnesses who agreed to cooperate decline, surveillance targets change their patterns, leads go cold in ways that experienced investigators recognize as the signature of compromised operations. The subsequent federal investigation attributes these reversals, in whole or in part, to the FBI's systematic protection of its asset. John Morris's role in the cover-up is both illustrative and, in its eventual resolution, one of the most consequential examples of institutional accountability working in precisely the wrong direction. Morris is not a handler, he is a supervisor. He is the person in the organizational hierarchy who is supposed to review what Connolly reports and verify that the reporting accurately reflects the informant relationship's operational realities. He accepts money from Bulger. He participates in meetings where law enforcement intelligence is shared with Bulger. He approves informant reports he knows are incomplete. He signs off on assessments of the relationship that systematically understate its costs and overstate its legitimate intelligence value. When Morris eventually cooperates with federal investigators, he provides testimony that is essential to the Connolly prosecution. He describes what he knew and when he knew it and what he did with that knowledge. His testimony is detailed, specific, and credible in ways that make it the cornerstone of the government's case against his subordinate. The government grants him full immunity from prosecution, not partial immunity. Full immunity. He is never charged with any crime. He retires from the FBI. He lives in the American Southwest. The government decides that testimony from a corrupt supervisor against a corrupt handler is worth more than accountability for the supervisor's corruption. The 2005 DOJ Inspector General report, reviewing the documentary record of what FBI supervisors at multiple levels knew about the Bulger relationship, and when finds that multiple points in the relationship's history produced internal documents or reports that should, under standard FBI supervisory procedures, have triggered a formal review of the informant's activities and the relationship's continued appropriateness. A 1981 memorandum from the Las Vegas field office raises concerns about the Wheeler murder's connection to organized crime figures. A 1985 internal review notes concerns about Bulger's ongoing criminal activity and recommends closer management. A 1988 supervisory assessment by James Ring raises the specific concern that Bulger may be using the informant relationship for his own competitive purposes. None of these documents produce a formal review of the relationship. Each is received, noted, filed, and ignored. The relationship continues. The specific human cost of the cover-up's success is most clearly visible in the cases of people who approach the FBI for help and receive, instead, a death sentence. Brian Halloran is the clearest example, but he is not the only one. Multiple witnesses and potential cooperators who make contact with the FBI's Boston field office during the Bulger years are subsequently identified as having been exposed by Connolly's intelligence sharing. Some of them survive. Some of them don't approach the FBI again after the first contact produces no results. Some of them never know why the protection they thought they were receiving turned out to be worthless. The specific institutional indignity, the aspect of the cover-up that is hardest to process after the fact, is that the FBI is simultaneously presenting itself to the public as an organization whose purpose is to protect people from organized crime, while actively degrading the ability of potential witnesses and cooperators to be protected from the organized crime figure it is secretly maintaining. The public-facing FBI is running anti-crime programming, maintaining a tip line, prosecuting organized crime figures in other cases, and generally performing the role of a law enforcement institution committed to public safety. The private operational reality in the organized crime unit of the Boston field office is that the FBI's informant is safer because the FBI protects him, and the people who might provide evidence against him are less safe because the FBI tells him who they are. This is not a secondary effect of the informant program. It is a direct, logical consequence of the program's design. When you protect a murderer's ability to operate in exchange for intelligence, you necessarily make the people who might stop him more vulnerable. The cover-up is not separate from the program, it is the program. The specific institutional logic of the continued relationship is never written down explicitly. No FBI supervisor produces a memorandum stating that the Bureau is knowingly allowing its informant to commit murder and is choosing to maintain the relationship anyway because the intelligence value exceeds the cost in lives. Such a document does not exist. It does not need to exist. The institutional incentive structure produces the same result without explicit authorization, through the accumulated choices of people who understand what the system requires of them and make those choices accordingly. Event 8. The Crack, How Everything Fell Apart, 1994-2002. The unraveling of the FBI's protection of Whitey Bulger does not happen suddenly or cleanly. It happens through a convergence of several independent processes, a federal criminal investigation that is more skeptical of FBI intelligence than its predecessors, a journalistic investigation that has been building evidence for years, and a congressional inquiry triggered by a case of FBI misconduct so egregious that it cannot be contained within the normal mechanisms of institutional self-protection. The federal criminal investigation is anchored in the work of Assistant United States Attorney Frederick Wishack, who begins in the early 1990s building a case against the Winter Hill Gang through a combination of witness cooperation and documentary review that is, from the beginning, notably independent of the FBI's Boston Field Office's Organized Crime Unit. Wishack is aware, as an experienced federal prosecutor in Boston, he is necessarily aware that the FBI's organized crime intelligence has a complicated relationship with its actual knowledge of the Winter Hill Gang's activities. He builds his case through other channels: witness cooperation agreements, financial record analysis, investigative work that does not root through the organized crime unit that Connolly ran for 15 years. The witnesses Wishack develops include Kevin Weeks, Bulger's personal associate for more than a decade, a man who has participated in the planning and concealment of murders, who has served as a lookout, an intermediary, and a logistics manager for crimes including multiple killings. Weeks pleads guilty in 1999 to 5 counts of murder and agrees to cooperate fully with federal investigators. His cooperation produces a complete inside account of Bulger's organization, its operations, its personnel, its crimes, that is, in crucial respects, different from the picture the FBI's official files on Bulger have presented. Weeks also helps investigators locate the bodies of Deborah Davis and Deborah Hussey, buried under a former gas station in South Boston. He knows where they are buried because he was present when they were put there. Stephen Flemmi is arrested in January 1995, his arrest enabled by Weeks's cooperation and the documentary record assembled through Wishack's investigation. Flemmi's defense team, in the proceedings that follow his arrest, begins reviewing the government's evidence and pursuing discovery in ways that produce a specific discovery that opens the institutional case. Flemmi was an FBI informant. His defense attorneys argue that his informant status and the FBI's knowledge of his criminal activities constitutes a government misconduct defense that may affect the admissibility of evidence against him. The argument, however ultimately unsuccessful as a legal defense, forces the government to produce documentation of Flemmi's FBI informant relationship, which in turn forces the production of documentation about Bulger's informant relationship and about Connolly's role in both. The journalistic investigation is the work of Dick Lear and Gerard O'Neill, reporters at the Boston Globe who have been covering the Bulger story for years and who published their comprehensive account, Black Mass, the true story of an unholy alliance between the FBI and the Irish mob, in 2000. The book draws on court records, FBI documents obtained through litigation, and interviews with law enforcement officials, former organized crime associates, and others with direct knowledge of the Bulger FBI relationship. It is the document that brings the full dimensions of the arrangement to a public audience and that establishes, in a form accessible to non-lawyers, what the federal court proceedings have been establishing in a form accessible only to people reading trial transcripts. The congressional inquiry is launched by the House Government Reform Committee in 1999 under Chairman Dan Burton through the specific entry point of Joseph Salvati. Salvati is a man who spends 30 years in Massachusetts State Prison, 4 of those years on death row, for the 1965 murder of Edward Deegan, a murder he did not commit. At the time of Salvati's conviction, the FBI had informant intelligence from an informant named Joseph Barboza, who later recants, establishing that Salvati was not present at the murder. The FBI does not disclose this intelligence to the defense, to the prosecution, or to the court. It buries it because disclosing it would have required disclosing the informant source, and protecting the informant source was deemed more important than the freedom of an innocent man. Salvati is exonerated in 2001 when the buried FBI documents are produced in federal court proceedings. He files a civil suit. The federal judge who hears his case, Judge Nancy Gertner, awards Salvati and his wife $36 million in damages. Salvati's case is legally separate from the Bulger-related civil cases. But it establishes the same fundamental finding, that the FBI's protection of its informant program directly causes the imprisonment of innocent people, and that the federal government is liable in tort for the conduct of the agents who made that choice. The 1998 federal indictment of Bulger, charging him with racketeering and 19 murders, is the mechanism that forces the formal disclosure of his FBI informant status. The indictment follows the cooperation agreements with Weeks and others, which produce documentary and testimonial evidence sufficient to support the charges without reliance on Bulger's own presence in court. Bulger, forewarned and long gone to Santa Monica, is not present to be arrested. He is on the 10 most wanted list. He will remain there for 13 years. The period of Bulger's flight, from December 1994 to June 2011, is 16 years, not 13. The listing on the 10 most wanted is real. The fugitive investigation is real in its formal existence. What is not fully established in the public record is whether the investigation is real in its operational urgency. Former FBI officials, speaking in the years after Bulger's capture, describe the fugitive investigation as resource-constrained and as having suffered in its early years from the same institutional dynamics that characterized the Bulger operation itself. A reluctance at the organizational level to pursue a case that would require the Bureau to document, in an arrest warrant affidavit and subsequent prosecution, exactly how Bulger came to be a federal fugitive in 1994. Including the question of who told him the indictment was coming. The congressional investigation adds a dimension to this picture. The House Government Reform Committee's hearings on FBI informant abuses, which run from 1999 through the early 2000s and eventually produce hundreds of pages of testimony and documentary record, established that the FBI's institutional response to the disclosure of the Bulger-Connolly relationship is, in several specific respects, designed to limit rather than expand accountability. Committee investigators find, in their review of FBI internal communications from the period immediately following Connolly's indictment, evidence of institutional concern about the reputational and legal exposure of the Bureau, arising from the full disclosure of the informant program's operation in Boston. The concern is legitimate. The liability the Bureau faces is real, but the institutional response to legitimate legal concern shades into institutional management of the information environment in ways that the committee finds troubling. The hearings produce, among other things, the Salvati case's full public airing, which establishes a principle that extends the Bulger case in a direction even more damning. The FBI does not only protect its informants from external accountability, it sacrifices innocent non-informants to protect its informant program. Salvati goes to prison for 30 years so that the FBI's source in the Deegan murder case does not have to be disclosed. The math of institutional self-preservation, 30 years of a man's life in exchange for maintaining the secrecy of a classified informant program. Event 9, the trial of John Connolly, the FBI agent who went to prison, 2000–2008. John Connolly is indicted in December 1999, 9 years after his retirement from the Federal Bureau of Investigation, charged with racketeering, obstruction of justice, leaking information that led to murders, and related offenses arising from his management of the Bulger informant relationship. He is 60 years old. He has been living a comfortable post-retirement life in suburban Boston, consulting for a telecommunications company, socializing in the South Boston networks that have sustained him for his entire professional life, and apparently operating under the assumption, not unreasonable given how long the institutional protection held, that whatever accountability might come for what happened in the Boston field office's organized crime unit would remain institutional rather than personal. The assumption is wrong. His federal trial opens in May 2002 in the United States District Court in Boston before Judge Joseph Toro. The prosecution, led by Frederick Wishak, presents the documentary and testimonial record assembled over years of investigation, FBI files, financial records of the payments Connolly receives from Bulger and Flemmi, cooperating witness testimony from John Morris and Kevin Weeks and others, and the specific documented sequences of intelligence sharing and subsequent murder that constitute the core of the case against him. John Morris testifies for the prosecution under his immunity agreement. He describes what he knows. He describes the meetings, the payments, the intelligence shared, the reports falsified. He is the supervisor who approved what Connolly did, and he testifies against the agent he supervised in exchange for the guarantee that he will never be charged. The jury convicts Connolly in May 2002 on racketeering, obstruction of justice, and leaking information that led to the murder of Brian Halloran. The jury does not convict on the murder charges themselves at the federal trial. The specific charges related to murder are treated differently under federal law than the related obstruction charges. Judge Toro sentences Connolly to 10 years in federal prison. 10 years for conduct that federal investigators spend years establishing includes passing intelligence that enables multiple murders. The families of the victims attend the sentencing. Some of them make statements. The disproportion between the conduct and the sentence is noted in terms that range from measured to searing by multiple family members and by advocates who have followed the case. Connolly appeals his federal conviction through the appellate courts while serving his sentence. He maintains throughout the appeals process and in subsequent public statements, interviews he gives from prison, letters, and through his attorneys, that he was a good FBI agent who operated within the framework of an institutionally sanctioned program, that the informant relationship with Bulger produced legitimate law enforcement results, and that the deaths attributed to his conduct are the responsibility of the people who committed them rather than the person who provided the intelligence that made them possible. He is not entirely wrong that the program was institutionally sanctioned. He is entirely alone in going to prison for it. The Florida prosecution is the second and more consequential criminal proceeding. The Broward County, Florida State Attorney's Office charges Connolly in 2005 with first-degree murder in the death of John Callahan, who was murdered at the Fort Lauderdale Hollywood International Airport in 1982. The legal theory is that Connolly, by passing intelligence to Bulger establishing that Callahan's continued existence represented a liability, set in motion the chain of events that resulted in Callahan's murder in Florida, making the murder a Florida state crime, and making Connolly a participant. The theory is legally creative and is contested vigorously through Connolly's Florida defense team. The Florida jury, after a trial that begins in May 2008, convicts Connolly of second-degree murder rather than first-degree. The judge sentences him to 40 years. Connolly is in his late 60s. 40 years is, functionally, a sentence he will die serving. John Connolly dies on September 17, 2021, in a Florida state prison of natural causes at age 80. He has spent 19 years in prison, nearly all of it in Florida state custody after his initial federal sentence concluded. He maintains until the end the self-conception he carries from the beginning. South Boston boy, good FBI agent, man who did his job in a program his institution created and authorized and rewarded. John Morris, his supervisor, dies in 2017 in retirement in the American Southwest. He is never charged with any crime. He lives 81 years, 42 of them after the conduct for which he receives full immunity. He testifies against the agent he supervised. He walks. He dies free. These two facts, Connolly's 40-year sentence and Morris's immunity, are the clearest possible statement of how institutional accountability operates when an institution is held responsible for the conduct of its own personnel. The person at the operational level serves the sentence, and the person at the supervisory level is the government's witness. There is a detail in Connolly's post-conviction public statements that deserves attention, not as a defense of his conduct, but as a window into the institutional psychology that produces it. In multiple interviews, he returns to the claim that what he did was sanctioned, that the top echelon program, the intelligence sharing, the protection of Bulger was institutional FBI policy, reviewed and approved at multiple supervisory levels, and that the decision to prosecute him is a retrospective criminalization of conduct that was, at the time he engaged in it, within the framework of what the FBI authorized. He is not entirely wrong about this. The program was authorized. The relationship was reviewed. Morris signed the reports. The Bureau commended his work. What he cannot account for, and what his public statements never meaningfully address, is the 11 people who are dead because of what he authorized in Bulger's name. The institutional authorization does not make them less dead. The commendations do not give Michael Donahue back to his 3 sons. The fact that supervisors who knew what was happening received immunity rather than prison time does not make Connolly's conduct less criminally culpable. It makes the institutional accountability less complete. Connolly goes to prison for a system that was larger than him. The system does not go to prison with him. The system, having delivered one of its operatives to criminal justice, continues. Event 10, the $100 million judgment the government pays for what it did, 2007. The civil litigation brought by families of Whitey Bulger's victims against the United States government is, in the history of federal civil litigation arising from the conduct of law enforcement agencies, a case without precise precedent. The plaintiffs are the surviving family members of people whose deaths the federal criminal prosecution record establishes were facilitated, directly, causally, through the specific operational intelligence provided by a named FBI agent to a named FBI informant by the conduct of the Federal Bureau of Investigation. They are the Halloran family, the Donahue family, the Wheeler family, the Callahan family, and others. The legal theory rests on the Federal Tort Claims Act, the statute that waives the sovereign immunity of the United States government and allows federal courts to hear civil tort claims against the government for the wrongful acts of its employees acting within the scope of their employment. The plaintiff's argument is that John Connolly was acting within the scope of his employment as an FBI agent when he managed the Bulger-informant relationship and provided the intelligence that led to murders, that the FBI created the program, assigned Connolly to it, supervised his conduct in it, and is therefore liable in tort for the consequences of that conduct. The government contests the cases through the litigation process. It argues, among other things, that Connolly's corrupt conduct falls outside the scope of his employment, that his personal corruption rather than his official duties is the proximate cause of the plaintiff's injuries, and that the extent of the government's liability should be limited by the factual specifics of each plaintiff's claim. These arguments are legally substantive and produced genuine litigation across several years. Judge Nancy Gertner, who sits in the United States District Court for the District of Massachusetts, who heard the Salvati case, who has reviewed more of the documentary record of FBI corruption in Boston organized crime enforcement than perhaps any other judicial officer, hears the consolidated Bulger-related civil cases and issues her judgment in July 2007. The judgment is $101.7 million. It is, at the time of its entry, one of the largest civil judgments against the United States government arising from the conduct of a federal law enforcement agency in the modern era. Gertner's opinion runs to more than 100 pages. It reviews the FBI's conduct across 3 decades with a precision and comprehensiveness that reflect her access to the documentary record assembled through years of criminal and civil proceedings. She finds that the FBI's agents and supervisors knew, or in the exercise of reasonable institutional oversight should have known, that their informant was murdering people. She finds that the FBI's institutional structure created the conditions for Connolly's conduct and provided him with the cover that sustained it. She uses the word outrageous to characterize the government's conduct. The word is a legal term of art with specific meaning in the context of tort law, and it is also, in ordinary English, accurate. The government appeals specific components of the damages calculation. The fundamental liability finding that the United States is responsible, in tort, for the deaths caused by the FBI's management of the Bulger-informant relationship is sustained through the appellate process. The government writes checks totaling $101.7 million to the families of people its agents helped murder. Patricia Donahue's check represents compensation for the death of a man who was giving someone a ride. The Wheeler family's check represents compensation for the death of a businessman who asked questions about financial irregularities in a company he purchased. The Halloran family's check represents compensation for the death of a man who walked into an FBI field office and asked for protection in exchange for information about organized crime. He was told implicitly and fatally that the FBI's relationship with his killer was more valuable than the information he was offering. Checks are real money. They are real accountability in the sense that the institution is made to pay a cost. They are not the accountability that would require asking why the program that produced these deaths continues to operate after the payment, why the supervisors who designed and maintained the program serve no prison time, and why the institutional logic that productive informants justify their costs is treated as a management problem to be improved rather than a moral position to be rejected. The Donahue family cashes the check. They would have preferred Michael Donahue. The civil judgment produces a specific additional finding that belongs in this record because it is, in its implications, as damaging to the FBI as the liability itself. Judge Gertner's opinion finds that the FBI's conduct was not the product of rogue individual agents operating outside institutional knowledge and control. It was the product of institutional policies and supervisory decisions that enabled, facilitated, and concealed the informant relationship's criminal dimensions across multiple years and multiple levels of the organizational hierarchy. The liability attaches to the institution, not merely to the individuals who implemented the institution's choices. This is the specific finding that the FBI's post-Bulger narrative most systematically resists. The narrative the Bureau prefers Connolly as a corrupt individual, Morris as a compromised supervisor, the Bulger case as an isolated instance of agents who went rogue, is directly contradicted by Gertner's opinion, which finds institutional causation rather than individual aberration. The distinction matters for the question of reform. If the Bulger case is individual corruption, you address it by removing the individuals. If it is institutional design failure, you address it by redesigning the institution. The DOJ IG report, 5 years before Gertner's opinion, reaches the same conclusion. This is a design failure, not a personnel failure. The reforms that follow the 2002 guidelines, the enhanced oversight, the IG follow-up assessments, address some of the design without fundamentally challenging the incentive structure that produces the design's most dangerous outputs. Event 11, the DOJ Inspector General, It Was Never Just Boston, 2005. The 2005 Department of Justice Office of the Inspector General report, formally titled The Federal Bureau of Investigation's Compliance with the Attorney General's Guidelines for Confidential Informants, is a document about a system, not a city. Understanding it as anything less comprehensive than a systemic indictment is the specific misreading that serves the FBI's institutional interests best, the reading that allows the Bureau to characterize what happened in Boston as a local failure produced by unusually corrupt individuals, isolated from the normal functioning of a generally well-managed informant program. The IG's investigation is mandated by Congress in the aftermath of the Bulger disclosures, the Connolly indictment, and the Salvati exoneration. Congress directs the Inspector General to examine whether the FBI's informant program, across the full range of its field offices and operational contexts, is being managed in compliance with the Attorney General's guidelines on the use of confidential informants, guidelines that were themselves revised in 2002, specifically in response to the Boston scandal, to impose new requirements for authorization of informant criminal activity, supervisory oversight, and documentation. The IG's investigators review hundreds of active informant files across multiple field offices. They interview handlers at multiple levels of seniority. They interview supervisors. They examine the documentation of otherwise illegal activity, authorizations, the formal approvals that handlers are required under the 2002 guidelines to obtain before allowing their informants to commit crimes in the course of their informant activities. What they find is that the institutional culture that produced the Bulger case is not a Boston anomaly. It is a national pattern, somewhat moderated in the years since the 2002 guidelines were imposed, but not fundamentally changed in the institutional logic that generates it. Specifically, the IG finds that FBI handlers across multiple field offices are regularly allowing their informants to commit crimes, including in multiple documented instances, violent crimes, without obtaining the required authorizations. In cases where authorizations are nominally obtained, the IG finds that they are routinely too vague to provide meaningful guidance about what the informant is actually authorized to do. The otherwise illegal activity, authorization, is, in practice, a rubber stamp issued to maintain the paper trail of compliance without the substance of genuine oversight. The informant criminal activity that is not reported upward is, in the IG's review, a systemic pattern rather than an individual aberration. Handlers across multiple offices decline to report informant crimes accurately, either omitting them from informant files, characterizing them in language that minimizes their seriousness, or structuring their reporting in ways designed to keep the informant relationship operational while technically satisfying documentation requirements. The IG identifies the career incentive structure as the primary driver. Handlers whose informants produce results are successful agents, and accurately reporting informant criminal activity risks terminating the informant relationship that produces those results. The report's documentation of specific field offices is careful about identifying ongoing investigations and protecting sources, which means the public version does not provide the granular city-by-city account that would make the systemic nature of the finding most viscerally apparent. But the aggregate finding is clear. This is not a Boston problem or a Connolly problem. It is a program problem. The program, by its design and by the institutional incentive structure surrounding it, produces the specific failure modes that Boston documents in the most extreme form. The IG's recommendations include mandatory pre-approval requirements for all informant criminal activity above a specified seriousness threshold, regular third-party reviews of long-term informant relationships by supervisors not involved in the day-to-day handling, enhanced disclosure requirements for informant criminal activity to law enforcement partners, and periodic congressional reporting on informant program compliance. The FBI formally accepts these recommendations. It produces a written response outlining the steps it will take to implement them. The IG conducts follow-up assessments of implementation. Those follow-up assessments find partial compliance. Some recommendations are implemented more fully than others. The documentation of informant criminal activity improves in some measurable respects, and supervisory oversight structures are strengthened in ways that are real if not complete. The fundamental institutional incentive structure, which rewards handler productivity and penalizes informant loss, is not changed. The incentive structure cannot be changed by a guideline revision. It is built into how the Bureau assesses and advances the careers of the agents who run its informant program. The 2005 IG report is publicly available. It is thorough, it is specific within the limits of classification, and its conclusions are not amenable to the institutional reframing that typically absorbs critical reports of government misconduct. It says in bureaucratic language that is precise enough to be clear to anyone willing to read it, that what the FBI does with its informants across multiple offices and multiple years is systematically inconsistent with the legal and ethical requirements of the program it operates. It does not say this about rogue agents, it says this about a system. The specific recommendations the IG makes in 2005 are worth naming, because the distance between the recommendations and what the FBI actually implements is itself a form of institutional evasion. The IG recommends that the FBI produce annual reports to Congress on informant program compliance, including aggregate data on the number of informants authorized to commit otherwise illegal activity and the number of informant criminal acts reported in each year. The FBI implements a version of this requirement. The version it implements is classified. Congress receives classified briefings. The public does not receive the data. The transparency that the IG recommends as a mechanism for external accountability is implemented in a form that retains all of the classification that made external accountability impossible in the Bulger case. The IG recommends that informant relationships exceeding 5 years in duration receive mandatory review by officials not involved in the day-to-day handling of the relationship. The FBI implements review procedures for long-term informant relationships. The implementation details are not publicly auditable. The adequacy of the implementation is assessed by subsequent IG reviews that find partial compliance, meaning that some long-term relationships receive the required reviews and some do not, and the consequences for noncompliance are institutional rather than personal. Fundamental problem that the career incentive structure rewards informant productivity and does not penalize informant criminal conduct is acknowledged in the IG report as the root cause of the systemic failure. The IG does not recommend a specific mechanism for changing the incentive structure because changing institutional career incentives is genuinely difficult and because the IG's mandate is compliance assessment rather than institutional redesign. The problem is identified. The mechanism for solving it is left to the institution. The institution that produced the problem is left to solve it. Event 12, Bulger's End, and the Accounting That Never Fully Comes, 2011-2019. James Whitey Bulger is found on June 22, 2011, in apartment 303 at the Princess Eugenia Apartments at 1012 3rd Street in Santa Monica, California. He is 81 years old. He has been living in the apartment with his girlfriend, Catherine Gregg, for most of the preceding decade. They are living as Charlie and Carol Gasco, ordinary retired people in a beachfront neighborhood, shopping at the local Ralph's, watching television, maintaining the daily routines of elderly people in a mild climate who do not call attention to themselves. Bulger's apartment walls conceal more than $800,000 in cash, along with 30 firearms. He has been hiding 3,000 miles from South Boston for 16 years. The tip that produces his arrest is not the product of the FBI's formal fugitive investigation, which has maintained his listing on the 10 most wanted list and periodically produces public appeals for information. It comes from an appeal broadcast on a television program in Iceland, focused specifically on Gregg, rather than Bulger, reaching Icelandic American community networks in which former South Boston residents might have encountered them. A woman who knows Gregg from the neighborhood recognizes her from the broadcast and calls the FBI's toll-free tip line. An ordinary citizen, watching a television program in Iceland, finds the man the Federal Bureau of Investigation has been publicly pursuing for 16 years. The arrest is made the same day the tip is called in. His federal trial opens on June 6, 2013, in the United States District Court for the District of Massachusetts before Judge Denise Casper. The charges are racketeering conspiracy and 19 counts of murder. His defense team, attorneys J.W. Carney Jr. and Hank Brennan, mounts a defense that contests the credibility of cooperating witnesses and argues that Bulger was not an FBI informant, but was instead using John Connolly's services as an intelligence asset without any reciprocal intelligence relationship. The argument is strategically constructed to prevent the introduction of certain evidence and to undermine the moral framing of the prosecution. It is not successful. The jury convicts Bulger on August 12, 2013. They find him guilty on 11 of the 19 charged murders, including the murders of Brian Halloran and Michael Donahue, the two deaths most directly traceable through the Connolly prosecution record to FBI intelligence provision. Judge Casper sentences him to 2 consecutive life sentences plus 5 years. He is 83 years old. The life sentences have a purely symbolic dimension for a man of his age, and the sentence's symbolic dimension is real. The United States federal court system has convicted the man the FBI spent 15 years protecting of 11 murders. Bulger serves the early portion of his sentence at the Federal Medical Center at Devens, Massachusetts. He is subsequently transferred through the federal prison system. On October 29, 2019, he is transferred to USB Hazelton in Brussetton Mills, West Virginia, a high-security federal penitentiary that houses, among other populations, organized crime figures with records of violence and retaliation. Bulger is 89 years old. He is placed in the general population at intake rather than in protective custody. On the morning of October 30th, 2019, he is found dead in his cell. He has been beaten. The weapons are improvised, a padlock inside a sock or a belt, applied to his head with force sufficient to produce the blunt force trauma that the post-mortem examination documents. Some accounts, sourced to law enforcement officials with knowledge of the examination, indicate that his eyes are injured in a manner consistent with deliberate mutilation after death. 3 men are charged in connection with the murder, 2 of them with organized crime ties. Federal investigators examine the circumstances of the transfer to Hazleton, the decision to place an 89-year-old high-profile government witness in the general population of a facility housing organized crime figures, and the examination, as of this video's research, has not produced formal accountability for whoever made that transfer decision. Stephen Flemmi pleads guilty to multiple murders and cooperates extensively with federal prosecutors. He receives life in prison rather than the death penalty in exchange for his cooperation. He is serving that sentence. John Martorano admits to 20 murders across his career as a Winter Hill enforcer. He cooperates with the Bulger investigation. He is sentenced to 14 years in federal prison and serves 12 before release in 2004. He is released in 2004 after admitting to 20 murders. He writes a memoir. He gives interviews. He goes home. 12 years for 20 murders is the arithmetic of cooperation agreements when the government needs your testimony more than it needs your imprisonment. No FBI supervisor goes to prison for the top Echelon program as it operated in Boston. Not the Sachs who signed off on informant reviews, not the unit chiefs who approved Connolly's reports, not the institutional hierarchy that created, maintained, and defended the program for 15 years while it facilitated murder. John Morris serves no time, he testifies, he walks. The institution that created the program continues to operate. It has won awards since the Bulger era. It has made significant organized crime prosecutions. It runs informants under the revised 2002 guidelines and the partial improvements the IG's oversight has produced. Whether those improvements are structural or cosmetic is a question that the classification of current informant files makes impossible to assess from outside the institution. This is the accounting that is available. 1 FBI agent in prison, dead after 19 years, $101 million paid by the Treasury, a public record that took decades to assemble, supervisors who walk, a program that continues. 11 murders while the FBI watched, 11 names the program decided were an acceptable cost. There's a passage in the federal civil judgment, Judge Gertner's 2007 opinion, that addresses the FBI's institutional knowledge of what it was maintaining. Gertner finds that FBI supervisors were aware of Bulger's murderous activities and took no meaningful action to prevent them. She finds that the Bureau's management of the informant relationship constitutes not merely negligence but conduct that rises to the level that the Federal Tort Claims Act requires for liability. The word outrageous in that opinion is doing legal work. It is also doing moral work. It is the judicial record's characterization of a sovereign institution using its authority and its classification system to protect a man it knows is murdering people. The cost is paid, the program is ongoing. The institution that made the decision has never been required to say, publicly and institutionally, that the decision was wrong. That is the accounting, say it plainly. That is all there is. The pattern that runs across every section of this video is not a series of individual failures or uniquely corrupt agents who happen to work in the same building. It is an institutional architecture, a set of incentives, authorizations, oversight structures, and information management practices that produces specific, predictable outcomes. When you build a system that rewards agents for productive informants and does not penalize them for the crimes those informants commit, you get agents who protect their informants' ability to commit crimes. When you authorize otherwise illegal activity without defining what that means, you get handlers who interpret it to mean whatever keeps their informant operational. When you classify informant files in ways that insulate the program from external oversight, you get a program that operates without accountability for as long as the classification holds. The people who broke this open deserve to be named. Frederick Wishak, the assistant United States attorney who builds the criminal case against Bulger through channels independent of the corrupted Boston field office's organized crime unit. Dick Lear and Gerard O'Neill at the Boston Globe, whose years of investigative work produce Black Mass and bring the full scope of the arrangement to public knowledge. Judge Nancy Gertner, whose 2007 civil judgment uses the word outrageous to characterize the government's conduct and requires the Treasury Department to pay $101 million to the families of the dead. The DOJ Inspector General's Office, whose 2005 report establishes that what happened in Boston is a systemic institutional failure replicated in pattern, if not in degree, across multiple field offices nationally. Patricia Donahue, who spends 25 years raising 3 sons alone while pursuing accountability through the federal civil courts, deserves to be named. The Halloran family, the Wheeler family, the Callahan family, the families of Deborah Davis and Deborah Hussey, whose remains spend nearly 2 decades buried under a South Boston gas station because the FBI was protecting the man who put them there. These families are the reason the civil record exists. They are the reason the government's liability is in the permanent federal court record rather than in the files that the FBI wanted to keep classified. Kevin Weeks, who cooperates with investigators and leads them to the bodies, is not a hero. He is a man who committed 5 murders and served 5 years in federal prison. But his cooperation is the mechanism through which the buried evidence becomes recoverable evidence, and his testimony is part of what makes the Bulger conviction possible. The institutional method documented in this video: develop an informant, protect his criminal activities, classify the evidence of that protection, and when the classification finally fails, ensure that the accountability attaches to individuals at the operational level while the institutional framework that produced their conduct continues to operate, is not unique to the FBI's top echelon program. It is a recurring pattern in the history of American law enforcement institutions, reproduced in different contexts with different names and different specific crimes, sustained by the same fundamental asymmetry. The institution controls the records, and the people harmed by the institution generally do not. The $101 million paid by the United States Treasury is real accountability in the most literal possible sense. The government is made to pay for what it did. The payment is real. The acknowledgement of liability is real. The institutional logic that produced the liability continues to operate. The informant program continues to run. The classification of informant files continues to make external oversight impossible. The career incentives that reward productive informant relationships and do not penalize the costs those relationships impose on the people outside the institution continue to shape the choices of agents and supervisors who will never appear in a federal court proceeding because no one will ever find the documents. History is not what happened. History is what we choose to remember, to teach, and to demand accountability for. The rest is what powerful people hope you forget. Don't forget. If this video reached you, share it, subscribe, leave a comment with the event that hit you hardest. Come back for the next one because there are more.